welcome back to Law Unfiltered. Now, we all know the phrase that cash is king. And obviously, in construction projects too, cash is king. Because why? Contractors rely on payments for them to finish up the project. For example, they have to pay salary, for manpower, for materials. All these things are important for them to finish the project in time. But not always cash flow is so smooth, right? And we all know that cash flow, especially in construction projects, is lifeline. So without that, the project will stop. Or worst case scenario would be that the contractor would go through bankruptcy. Now, knowing all these issues, the CIPAA Act, which is a Construction Industrial Payment and Adjudication Act, right? It's very long. So it was implemented. The purpose of having CIPAA, which is short for whatever I just said, is for the purpose of expediting financial disputes, especially when it comes to non-payment issues in terms of like construction projects. Now, what we're going to talk about today is not about the CIPAA procedure, but the fact that it may not be as quick as we think it is. So we're going to explore, like, if you're going through CIPAA procedure right now, if you have financial cash flow problems, so what kind of thing can happen when it comes to CIPAA procedures. And of course, I'm not doing it alone. Today, I have with me a special guest, Jason Chong.
Hi everyone.
Thank you for being here.
Thank you.
Yeah.
Okay, just about introduction about myself, a little bit one. My name is Jason. I'm the principal of Zer Chambers. The areas of practice I primarily practice is construction litigation, arbitration, of course CIPAA.
Yeah.
Really happy to be here today. I think it's a very interesting topic.
Right.
Especially to the young lawyers, I would say so.
Yeah.
Because CIPAA is something very new.
Yes.
Relatively new.
Complicated as well.
Complicated as well.
Yes.
Just a bit of history. The Act is 2012.
Yeah.
But it came into effect officially in 2014. So I think today we're going to explore whether CIPAA is truly an effective mechanism.
Correct.
As compared to arbitration or as compared to the court.
Correct.
All right. Now, a bit about CIPAA is that before CIPAA was introduced, the history was this. There were, in construction clauses, contract, mostly they have arbitration clauses.
Yeah.
Most of the time, right? Because you're talking about millions and dollars and billions and all these things, right? So because of that, many companies want to keep the dispute P&C, especially the big ones. So for example, let's say Apple, Samsung, let's say. They want to keep it P&C. They don't want, the market crash and things like that, especially if you're listed companies, right? So that is the whole reason why CIPAA was introduced. Why? Because what about the SMEs? What about those small companies that, let's say, the contract sum was only a few hundred thousands, or let's say if it's only $500,000. Okay, it's a lot to individual, but to a company, maybe $500,000. It's a 1 month overhead expenses
And
for a construction company.
especially when arbitration is so expensive
Correct.
as well. Yeah.
Correct. And then you have to fork out money first for arbitration, not knowing whether you can recover the money back.
That's true.
All right. Now, arbitration typically takes maybe, if it's fast, one arbitrator, maybe 1 year, 2 years. But if it's more than one arbitrator, let's say 3 arbitrators in one contract, then it would take up to 2 to 3 years. So I have one arbitration matter where the hearing, so it was filed notice arbitration in 2024, the hearing was fixed in 2027.
Oh God.
So it was 3 years later.
It's like civil courts already.
Worse than civil courts.
Yeah.
Yeah. So I wouldn't go to the extreme of arbitration is a scam. I don't think that's right. But equally, arbitration is expensive.
It's not so effective as well.
Correct.
Compared to CIPAA. That's where CIPAA comes in like quite special, right?
Correct.
In a way, like the timeline for you to file papers and also for the adjudicator to make a decision is like there is a very strict timeline within the CIPAA 2012 Act itself.
Correct.
So it's quick.
Yeah,
and
it's quicker than arbitration.
Correct.
Definitely quicker than arbitration.
Yes.
So the entire process of why CIPAA came in was because to aid the SMEs. That was the Parliament's intention. In fact, those judgments that we can see deriving from back then Her Ladyship Mary Lim, the Mary Lim, Azrul Lee Swee Seng, and then you have, Lee Swee Seng, you have Lim Chong Fong. So all these federal court judges, court of judges, right? Back then they were in High Court. So they have made it very clear that CIPAA was to aid the SMEs. Because of this concept of pay now, argue later. All right?
Yes.
Right. So now because of that, that's why a lot of SMEs, they are relieved in a way, because they don't have to claim for 100,000+,
Yeah.
but have to fork out almost half of it just to pay the administrative fees of AAC fees.
That's true.
The arbitrator's fees, the venue for rental, the premises, and all these things. So because of all these costs, that's why the SMEs, they will resort to CIPAA.
Yeah.
Now, fun fact about CIPAA is that it is a statutory right.
Yeah.
Right. So even if your contracts out of CIPAA, or even if your contract never mentions CIPAA expressly, you can still go for CIPAA.
Now it all seems like sunshine and rainbows, right? Very nice. But what if the person lose and they are unhappy with the decision? Of course, CIPAA cases, right, decision is non-appealable. But what they can do is they can apply to the High Court to set aside the decision. Now, there are 4 grounds to set aside the decision, but primarily we are going to focus on 2, which is on the denial of natural justice, and also the whether the adjudicator has
Exceeded the jurisdiction.
exceeded the jurisdiction. Now, let's focus on denial of natural justice first. When we say natural justice and all that, blah blah blah, what does it really mean? It means that you did not have the opportunity to go to the adjudicator and present your case as a whole, or maybe the adjudicator decided on her own facts and documents that was not even there against your case. I mean, layman terms, that's what it means. So, but this is I read a few articles and they said that most of the cases, right, people argue on that point itself, right?
Now, you're right. I think you're right, because most of the time when we apply to set aside a CIPAA decision, it was mainly on these 2 grounds, because the other 2 grounds
very hard to prove.
Yeah. Right. One is the fraud.
Yeah.
Right. Another one is biasness of the adjudicator.
Unless really got lah.
Correct. Yeah. So in fact, the biasness is actually a huge accusation. There are a lot of judgments that say that any lawyers, you cannot simply apply that clause or that section to set aside unless you really have good proof or evidence on that. Because the moment where you have accepted him to be adjudicator, you never disputed his jurisdiction and all these things. You never disputed his unfairness,
conflict of
interest. Then you are deemed to have accepted lah. So normally we don't go under that tangent. Now, breach of natural justice. We're coming back to that is that the court do not look into the merits of the case.
Correct.
Right?
Yeah.
So the Alpha Galaxy case by Justice Wong Kian Keong back then, I think he has succinctly summarized a lot of paragraphs, I think A to K. It's a huge summary where he will list down the situations where you cannot set aside despite all these situations.
Yeah.
Now, one of it is this. So let's say that parties have raised issues A, B, C, and D. Okay. Now, even if the adjudicator decided wrong, let's say issue B wrongly, right? Factually and legally speaking, he was wrong or she was wrong. His decision still cannot be set aside.
Yeah, because when you talk about that is called merits.
Correct.
What we want to set aside is that the adjudicator did not provide parties the
equal opportunity.
Correct, to go and say their case.
Yes.
I think another case would say that what if the adjudicator went, like I said again just now, like frolic of her own and decided on things that was not even there or was not even a dispute. So that is also a breach of natural justice.
Correct. Basically, you cannot decide on something that was not brought forward by the parties. Because then it will be, in a way, you are not affording equal opportunity to be heard.
Yes.
Both parties.
Yeah. So that is breach of natural justice. And then another ground, like we said just now, is that the adjudicator acted in excess of her jurisdiction. Now, jurisdiction in this part means how do we explain jurisdiction in layman term?
Or in layman term, basically, let's say you have a box.
Oh, okay.
Right? In a box, right? If let's say parties have ventilated all arguments and all issues within that box, so you can only decide whatever that is within that box, within that parameter itself.
Yeah.
The adjudicator cannot go out of it
Yeah.
to find some other arguments just to support the claim, no, even though the one of the parties did not plead anything on that.
Yeah.
Right? So basically, you have exceeded
On that
what
part.
you are only allowed to decide.
Correct. Yeah.
So you went beyond that lah.
Yeah.
So in a layman term, it's except for jurisdiction. Right.
Yes. So, but in that sense, right? Like, again, I know a lot of people argue on that, but you know, there is one issue with CIPAA is that, actually, I do not agree. I mean, my humble opinion, I didn't agree with it. Okay, now let's move back a bit. Okay, in CIPAA procedures, you start with payment claim.
Right.
Payment claim is to tell the person, right? You owe me this money.
Yeah.
Pursuant to this claim, that claim,
Correct.
finished already. Okay, then the opponent is supposed to give you a payment response. And whatever that is in the payment claim and in the payment response is what the adjudicator is supposed to decide on. Now, the problem is that back then, I don't know how long ago, I can't remember the
Right.
case already, the Bina Putri case, right? So now you don't need to really file even the payment response because it will as if like you are contending the issues that's in the payment
pursuant to
claim.
Section 6 lah. of
Yeah,
CIPAA.
correct. Pursuant to the act itself.
Correct. The act actually specifies.
Yeah.
that.
So what if I give you a payment response, I briefly say I disagree, I deny it, and then I give it to you. What are the grounds of my denial? The other side will not know, right? Or worst come situation, the person would not even file the payment response.
Right.
So now, it's like kind of like, so what is the jurisdiction of the adjudicator then? You get what I mean?
Understand.
Like, right? Like it's supposed to decide on whatever that's stated in there. But now that I'm not giving you the payment response, how am I supposed to know that what is exactly the adjudicator's jurisdiction? So that's one issue that's been going on and on in this recent years in the adjudicating CIPAA procedure, right?
So I think all these issues, all these conflict opinions arise because of it was decided before the view esteem case.
Is it the Bina Putri? View esteem is Bina Putri. I'm sorry, I can't remember.
So view esteem, you have High Court, all the way to the Court of Appeal, all the way to the Federal Court, right?
Yeah.
So back then, what happened was that parties will not file payment response, and then so in a way you never put forth your counterclaim in your defense, right?
Yeah.
So in a way you are giving people a surprise.
Yes.
Later on in your education response,
It's
you're
like an
gonna file-
ambush.
Correct.
Yeah.
So when people file payment claim, you don't do it. Then you file when you're supposed to file a education response. That is when you are
Adding things in
correct.
already.
Correct. So
Yeah.
so you're giving people a surprise.
Yeah.
So the
That's not
courts,
fair.
that's not fair.
Yeah.
So that was the court's approach back then.
Yeah.
Okay. That no, even if you did not file a payment response, okay, fine, your defense can still be considered because of Section 6,
Yeah.
but your counterclaim cannot be considered. So there were a lot of debate lah. Then people will say, then what about Section 6? Then you are making Section 6 redundant because Section 6 says that you don't have to file payment response. In any event, you are deemed to have disputed the whole thing. So then it all went all the way to the Federal Court.
I think it's the first case, right, that went to
Yeah.
Federal Court for CIPAA.
Correct. That's the main, the huge,
The first one.
important case, the
Yeah.
landmark case, right?
Yeah.
So when the Federal Court, so the Federal Court says that no, the adjudicator has the obligation to look at not just the payment claim, payment response,
But everything.
but everything.
yeah.
So in a way, even if you never file a payment response, you are still obligated to consider the education response.
Okay, but I have a question.
Yeah.
Isn't it a bit contradicting to Section 29, I think?
Yes.
Right.
Correct. So in a way, there is a bit of conflicting positions
Yeah.
in that sense.
Yeah.
But if I were to put myself in the view esteem shoe, the judge's POV, I was just thinking that maybe it is also beneficial to the lay people. So for example, let's say some construction companies that receive payment claim, they couldn't afford lawyers at the point of time, and then they didn't know the due date to file payment response here and there, right? So they missed out. Now, because of that, then later on they have counterclaim, which then later on if the adjudicator says that, oh, actually we cannot consider because you never put in payment response, then in a way it will be like a denial of natural justice per se. If I were to put it that way, I put myself in the shoe of the federal court judge in that way. So I find it makes sense also, because then it doesn't make the Section 6 redundant, because it's not a mandatory requirement for you to file payment response. But as a legal practitioner, if client comes to me, even if client comes to me that today is a due date for me to file payment response, I will still file payment response for the client, just to put on record that, look, I have a counterclaim. Right? Because there are adjudicators that sometimes they just overlook, or sometimes they just in a way maybe they're not updated with the law, because adjudicators not all of them are lawyers. Some of them are maybe not legally trained.
That's
right. Maybe, I mean, of course they have trainings and all these things, but maybe they have overlooked, right? So for me, I always want to reserve my client's right to say that we have a counterclaim and or set off, which we reserve our full rights in putting it in our adjudication response.
Oh, so at least there's something there, right?
Correct.
Yeah,
correct.
yeah.
So I think to be safe, of course, as a legal practitioner, you always have to all the clients who are watching this, please don't come to us at the last stage and expect us to file a counterclaim on
it's
that.
I think it's within 10 days, right? You have to file a payment response.
Correct.
Okay, so
10 days.
so anyways, like we said, so those are the setting aside grounds. And then besides setting aside, the losing end can also file an application to the High Court to stay the adjudicator's decision. Stay meaning you're trying to put a pause to the decision first, pending your setting aside application at the High Court, if that makes sense. Means like, for example, now I want a person to pay me, the adjudicator say this person has to pay me 50,000, for example. So obviously I'm not happy with it. I want to hold up first. I don't want to pay you first. I want to go to the High Court to set aside this decision because I'm not happy with it. It's, in my opinion, not right. And while I set aside, I also have to ask for the High Court to let me pause first. I don't want to pay first. Something like that. Now, but even when you apply for set aside, right, it's not necessarily that the whole entire decision itself would be set aside. So for example, we have claim 1, 2, 3, 4 that we are contesting.
Right.
And the decision is that 1, 2, 3, 4 I have to pay the claims in 1, 2, 3, 4 payment claim. Now maybe 1 and 2, right, is tainted with natural or the denial of natural justice, and then 3 and 4 is fine, it's prim and proper. So the court may say that there's something called the principle of severance. Right? Do you want to add up on that?
Now, so I think you have pretty much covered the basic of it. To a layman's understanding is that you claim 4 things. Let's say one of the claims which has been allowed by the adjudicator, she exceeded the jurisdiction for that particular claim. So only that claim will be severed, will be set aside.
Correct.
But the rest will remain. So I think that's the understanding of a severance in that sense.
I think that's what the purpose of this, right? Actually, it falls back on CIPAA, like what you say, you know, it's trying to help the SME, right? They're trying to expedite payment issues. So to ensure justice, and also to preserve the purpose of CIPAA itself, you don't want to, set aside the whole thing and then you have to redo the whole thing again. Then it kind of like wasted a lot of time, right? That's not expediting the dispute. To reach a finality to the dispute, so that's why they said that, look, maybe this particular issue is fine, but we don't have to set aside that thing as well, so we can proceed with it, pay up the thing so that the lifeline of the project will continue going on. If not, the project will fail. So, and I read somewhere they said that construction is the backbone of a economy in a country,
Yeah.
right? So we don't want that to happen, especially nowadays, right? Because of the uncertainties we live in, we have COVID, and then we have war, and then other than paying for workers, for materials,
Yeah.
you also have to absorb the fluctuation of material cost.
Yeah. The diesel.
Oh, yes.
A lot of my clients, they complain
Diesel.
because of the diesel. And a lot of contracts they are screwed lah, I would say. Because so most of the contracts will say that any fluctuation of the price is not going to be my problem, right?
Yeah.
From the main cons perspective or from the client's perspective. So because of all these issues, for more reason for us to invoke CIPAA, especially for those claims, like progress claims or certified claims and all these things. So, coming back to this severance, I think we have pretty much summed it up all that. But in terms of the stay, I think that is very important because for stay, most of the time in practice, normally the judge will say, look, parties, are you going to contend on the stay or the execution? Now, if not, then I'll just grant an ad interim. So an ad interim will just, in a way, pause the execution first for now, pending the disposal of the setting aside. So most of the time, parties will save the costs on the legal fees or any cost for this stay application. Unless if it's really, like what you say, cash flow. The company, let's say, I really need the money now. So the stay that they will fight, no matter what they will fight, of course, then it goes under Section 16 of the CIPAA Act. And then Section 16 says that if you have applied to set aside, that's the first precondition you have satisfied to apply for stay. But that is not the only condition. Because view esteem comes
Exceptional
in. A lot of requirements, a few hurdles and all that. So then view esteem comes in to say that, look, just because you have filed setting aside application or you have filed an notice arbitration,
you can't get stay as well.
You can't. It's not an automatic stay. Of course, one of the factors which in my POV, I still think is still a denial to the access of justice for the SMEs is the financial situation, which is one of the factors why the stay will have to be allowed. So for example, let's say the SME's financial situation is not so good, even though they want a CIPAA decision, but the court is worried that what if the losing party is to pay you first, but later on when they manage to set aside, you are not able to vomit the money back out. So this is another issue that I always tell clients. I say, now coming back to this again is a very stringent requirement because the whole reason why you go for CIPAA is for cash flow.
Yeah.
But you're using cash flow as a factor, the company's financial situation as a factor to stop me from getting my money fast. So normally when client comes to me, they want to start a payment claim, right? The first thing I'll ask them is that, okay, how is your financial situation, your financial standing in the company? That's the first thing I would ask because I would have already foreseen that not only payment claim is going to start, it's going to go all the way to the High Court. It might even go to the appeal, right? So then I ask my client, okay, how is it like? So if they say that, okay, if they are in a not bad situation, then okay, maybe we can do about it. But if they are really in the, let's say, in the very insolvency stage per se, let's say, right? Or like they're near to that, nearing to the JM application going to go for judicial management, or they are almost to the extent where they're going to go for the scheme of arrangement, right? All these things, right? So when you have that kind of situation, I would always tell them to think twice, because sadly to say, CIPAA is useful and helpful from the beginning, but it's still a rich man's game towards the end. That's how I see it. Sadly, I have to accept that, because many cases have suggested that impecuniosity is also one of the factors to grant the stay. So you would have to prepare at least 1 or 2 years of funds for you to be able to completely exhaust the entire CIPAA and post-CIPAA mechanisms.
Yeah.
So if you are in that verge of insolvency stage, then you might want to see whether it's practical for you to do a commercial settlement or discussions with the other side instead of filing a payment claim straight. So that is a another way of
At least
doing it.
there is room for discussion.
Correct.
To mediate the matter.
Correct. So if you have the financial standing, okay, good for you. But I'll tell you the whole procedure, the whole process. CIPAA, it will take like what, 3 months, 4 months?
Yeah, actually.
It's very fast.
Very
actually.
fast.
Correct. But it's just that
there are other avenues.
Correct.
After that, yeah.
After that, so if you go for high court setting aside and force, so now recently the construction courts, they're very fast. They make it around 3 to 4 months. To get the enforcement and setting aside application done in 3 to 4 months. Then after that you have appeal, let's say. They appeal to Court of Appeal and here and there. And of course, if you have novel issue of laws, you can satisfy the Terengganu Forest case, then you can go to the federal court for leave application on that. But and then also there's another benefit of CIPAA is that if you win the decision, you may complain to the father directly. Now, so you have a client, you have a main con, you have subcon. So subcon won a decision. Now, subcon will then ask main con to pay up.
Yeah.
If main con refuse to pay up, then subcon can go straight to the client, bypass the main con under Section 30 of CIPAA Act for direct payment clause. So in a way, they can bypass and go straight to the so-called the father lah, I would say, to the parents who complain, hey, your son is not paying me. But of course, you can only use that if you prove 2 things lah. One is the CIPAA decision is in favor of you, and 2, at the point of you issuing that so-called direct payment claim to the client actually owes money to the main con.
So if the client already paid the main con that particular amount of money,
nothing can get.
Then I just enforce it at the High Court against you, lor.
Yeah. So either you want to go straight to the High Court, or you want to just try to enforce, or you can do concurrently.
Now let's go back to our main question.
Yeah.
So is CIPAA illusionary or?
Someone is gonna quote me for this.
Okay, I think CIPAA procedure itself is fast.
Yeah.
It does try to get the aim that they want to. The problem is not with CIPAA procedure itself, like the main procedure, but the after decision procedure.
Correct. Post CIPAA.
Yeah, post CIPAA decision. That is the problem. But you cannot say that really is a problem because we cannot just side with one party, right?
Yeah,
the law
correct.
must strike a balance to also help the other side.
Yeah.
What if the decision was really wrong, right? So I wouldn't say that it's illusionary. I would say that it's trying to strike a balance for both parties.
Well, that's a very diplomatic answer. But which is true.
Which is true.
In the courts. Past precedents is true. The courts, even the Court of Appeal, they have been trying to say that balance must be struck, right?
Yeah.
Must be balance between both sides.
Yes.
Which I agree with it. I don't think CIPAA is illusionary. I don't think so. CIPAA definitely is helpful.
Yes.
Is useful. It gives pressure, not on a legal POV but also in a practical POV. So, for example, let's say you launch a CIPAA. You can report to SITOS, which in a way it might affect the other side's reputation, bank facilities,
If they want to get a loan,
correct.
That's very problematic.
Way, at least it's still something,
Yeah.
The only issue is the enforcement part where you also have to pray that you get a very good adjudicator. You really have to pray hard because adjudicator normally it's appointed randomly, right? So long as there is no conflict to act to listen dispute for both parties, then AIC will make the appointment, right? If you get an adjudicator that who is very legally trained, who is very technical in terms of the contract clause, all these things, then you can see that they don't really care much about the quantum. They care a lot about the preconditions. They care about the technicalities, the clauses of the contract. But if you get an adjudicator who is like QS based, right, or AR or IR, right, they may have a different view. They may use equitable arguments or principles to try to help you, to say that, look, by conduct you have accepted it, blah, 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 all these things. And maybe don't really stick too much on the technicalities of the clauses. So that is...
It's good and bad.
That's good and bad, correct. So, but they have adjudicators where like really make the wrong decision. and really screw up in writing.
It's okay.
So,
Legal fees.
for wow, okay. I mean,
See legal fees.
yeah. We have educators. I mean, I've experienced personally on that. But of course, we do have good educators, really good ones.
I think the problem is that there's too many educators now.
Yeah.
I went through the AIAC list the other
Oh, it's a lot. A lot
like,
of educators.
How do I choose now? I don't know. Like, there's so many, and I'm like, who's good? I don't know who's good. I assume all's good. They are there, and educators have to go training every year.
Correct.
Like within a period of time, they have to go in that year itself. So it's not like this after they become educated, they stop training and already. So I assume it's all good lah.
There's a standard lah.
Yeah,
Obviously there's standard over there.
But you don't know who to choose. There's so many.
Correct. So ultimately, AIC will choose for you.
Yeah.
That is in my POV. I still always tell client, they have 1% luck of getting not a good adjudicator in that sense. Or you can see sometimes some decision of civil decision by the adjudicator, it's a very rushed decision. Sometimes he or she just wants to maybe
get it over with.
Yeah, maybe he or she just read through maybe few days before the due date to deliver decision, and then just run through it like that. So I've seen decisions like that, which is in my POV, you are taking a risk lah. You're making a risk that the decision can be set aside.
I think we can conclude this episode.
Yeah.
Thank you so much for listening or watching this video. I hope it helps. We try to cater the episode to layperson so that people can understand. Not everything is like legal terms, legal words everywhere. It's so complicated. Thank you for being here, Jason.
No worries, thank you.
I had fun. I hope you did too.
Yeah. A few of very challenging questions.
Is
a
it?
few of very very dangerous questions.
Well, he answered with like this is nothing. Anyways, okay then. I'll see you guys on the next episode. Bye-bye.
Bye.